Yes, sir.
Before you call the case you think I might be here on, I've had a chance to talk to Miss Seeley. She was in the MIDC waiting room, and I explained the charges to Miss Seeley. However, she would like to know under which jurisdiction I operate. I've explained that I'm a criminal defense attorney and I don't operate under any jurisdiction, so I don't think she's seeking the services of an attorney at this time, and the court may like to speak with her.
Alright, buckle up because this one is a masterclass in what happens when internet legal theories collide headfirst with an actual courtroom. Today we're watching a defendant who checks two very volatile boxes: self-proclaimed sovereign citizen and full-blown courtroom Karen energy. That combination almost always guarantees one thing: chaos. Now here's what makes this case especially interesting. She's not just arguing facts, she's challenging the very authority of the court itself. That means instead of defending against speeding, no proof of insurance, and driving on an invalid license, she's going to try to put the entire legal system on trial. And that never ends well. Pay close attention to how the judge handles repeated jurisdiction arguments, how the defense attorney responds when she refuses representation, and how the escalation builds minute by minute. Because what starts as a routine pre-hearing quickly turns into a textbook example of why misunderstanding jurisdiction can land you in even deeper trouble. And trust me, by the end of this, when she declares she won't show up to trial, that decision sets up the inevitable outcome. Let's watch this unravel in real time.
Thank you, Mr. Batar.
You're welcome, Judge.
These are 23HR0457A, B, and C. These are Huron Township versus Bonita Seeley. Ms. Seeley, were you able to hear Mr. Batar just now?
Oh, first of all, are we on the record?
Yes, ma'am.
Okay, are we under penalty and perjury?
Are we on what, ma'am?
Under penalty and perjury, if you're willing to swear in.
I'm sorry, ma'am, I can barely hear you.
I said, is everybody willing to swear in under penalty and perjury?
Ma'am, we're not taking testimony as of yet. Today is the day and time scheduled for the pre-hearing and adjourned arraignment pretrial in these matters.
It still has to be placed on a record. He still has to be put under penalty and perjury because he's swearing to an alleged crime against it and holding me accountable. So even though this is just a hearing, it still has to be put on notice for the public as well.
And here it is, the first red flag. The court-appointed attorney has already tried to explain the charges, but instead of asking about strategy or evidence, she's questioning jurisdiction. This is a common sovereign citizen tactic. Shift the focus away from the alleged violation and toward challenging the authority of the court itself. Notice something important. The attorney calmly clarifies he doesn't operate under a jurisdiction because he's defense counsel. He's not the state. He's not prosecuting. He's there to help her. But instead of seeing that as an opportunity, she's treating him like part of some illegitimate structure. His is the turning point where she effectively walks away from professional representation. And that's a risky move when you're facing a misdemeanor charge.
Ma'am, today is the day and time scheduled for the pre-hearing and the arraignment pretrial. Would you state your name for the record, please?
Bonita Seeley.
Ms. Seeley, Mr. Batar is the court-appointed attorney assigned to this courtroom for the day. He's indicated that you don't wish to engage his services. Is that correct?
No, let me explain my position. I asked him a simple question about jurisdiction. That's why this hearing has been re-adjourned for today, because the last hearing, none of the attorneys could answer the question in regards to what jurisdiction that we're operating under. So they want to proceed without addressing the jurisdiction, which is a violation of due process. So in order for him to be represent me on any public record, I have to understand what jurisdictions he's operating on.
Ms. Seeley, if you do not wish to use the court-appointed attorney, and you confirm as much to the court right now, Mr. Batar can go back, ma'am. Mr. Batar can go back and do other things that he needs to do this morning. Do you wish to use Mr. Batar's services, or do you wish to represent yourself this morning, or do you wish to retain counsel through some other mechanism?
Under what charge, under which jurisdiction, and then who's bringing the charges against me?
Ma'am, there were citations issued against you in Huron Township for limited access speeding 11 to 15 miles per hour over the posted speed limit. That's a civil infraction. There's count 2, no proof of insurance. And there is the misdemeanor of driving while license not valid or improper license. Do you wish to use the services of the MIDC attorney, or do you wish to represent yourself this morning, or do you wish to retain counsel?
Who are the parties bringing this claim against me? It's a simple question.
Now pay attention to how routine this proceeding actually is. This is a pre-hearing and arraignment pretrial, not a trial, not testimony, not evidence presentation. The judge is simply confirming identity, representation, and scheduling. That's it. But when she insists that everyone be sworn under penalty and perjury, she's applying courtroom rules that don't fit this phase. No testimony is being taken. No one is making factual assertions under oath. Yet she's framing it as though constitutional violations are happening in real time. This is where misunderstanding procedure becomes self-sabotage. Courts operate under structured phases. If you don't recognize what stage you're in, you end up arguing the wrong issue at the wrong time and frustrating the court in the process.
You're
I
trying to
answered your
avoid this
question, ma'am. I answered
Who's
your
bringing
question,
the
ma'am.
charge?
I answered your question, ma'am.
And could you re-answer it? Because I didn't hear it. Who's bringing the charges against me?
The citation that was issued to you was issued by an officer from Huron Township, Freddie Yono. It's the citation that was issued, is signed.
So it's
It
Freddie.
has his name and his ID number. Ma'am, my question to you is, do you wish to engage the services of the court-appointed attorney, or may I release him to go back to do some other work?
Wait a minute. I have questions before I can answer on. You're trying to get me to
No,
avoid
ma'am.
questions that you
No,
know-
ma'am.
Yes, it's
No,
a
ma'am.
due process violation. Objection. Yes.
Miss
Because you're not
Seeley,
hearing
this
me.
is
This
the
is a
Miss
hearing.
Seeley, this is the third and last time I'm asking you. Will you be using Mr. Batars to represent you this morning, or do you wish to retain your private attorney, or do you wish to represent yourself?
I need to understand what jurisdiction we're under.
Mr. Batar, you may return to your breakout rooms to meet with other potential clients. Thank you.
Thank you, Your Honor.
Your Honor, if I
Ms.
may,
Seeley, do you intend to represent, I'm sorry, Ms. Foley Carter.
I just want we started this case back in July. Ms. Seeley attended her first pretrial. She demanded that the case be dismissed. I declined. I asked that the case be set for a bench trial. Ms. Seeley objected, and Magistrate Hinman advised her to file a motion stating her objection. Since then, she asked Judge Green for her oath of office and then didn't appear for the court dates before Judge Oakley. So this case has been going on for quite some time with no resolution.
Because I'm asking a question and it requires a rebuttal when it's being ignored. You cannot violate the due process. This is a hearing, and any questions that I have needs to be answered. You don't get to sit in the capacity of government and ignore the questions that the people have. Someone's bringing a claim against me, and my only question is, are we dealing in a commercial or a common law, also known as a record of law, court? That's simple. So are we in a common law court, yes or no?
Here's the key moment. The judge is giving her a very clear choice. Use the appointed attorney, hire private counsel, or represent yourself. It's straightforward. But instead of answering, she circles back to jurisdiction again. This is critical because courts interpret refusal to answer procedural questions as obstruction. The judge isn't debating philosophy, he's trying to move the docket forward. And every time she pivots back to jurisdiction, she's effectively declining representation without formally saying so. And here's the irony. If jurisdiction were truly flawed, a competent attorney would raise that properly through motion practice. But by rejecting counsel, she removes the very person equipped to make that argument effectively.
Marianne, a in-person bench trial date in this matter, please.
Objection. Objection. Are we in a common law court, yes or no?
January
Case
23rd
dismissed.
at 11 o'clock.
Case dismissed. Case dismissed because you refuse to rebuttal to the question regarding jurisdiction. You cannot proceed without honoring the jurisdiction. You cannot be in
Ms.
the capacity
Seeley?
of a... Yes.
The misdemeanor matter and the 2 civil infractions that are traveling with it that were issued on April 26, 2023 will be set for an in-person bench trial in courtroom number 1.
Objection. I will not be showing up. Objection. I will not be showing up. You refuse to answer the question of jurisdiction. You're trying to get me into the courtroom so you can take me against my will and lock me up in a cage like an animal. Objection.
When she keeps asking who's bringing the claim, the judge answers, the citation was issued by a township officer. That's how traffic and misdemeanor citations work. The state enforces traffic laws through its officers. But listen closely, she's not looking for clarification. She's looking for a trigger phrase. Sovereign citizen arguments often hinge on commercial versus common law distinctions, or on the belief that courts are corporate entities without authority. The problem? None of that nullifies traffic laws. Statutory courts handle statutory violations. Speeding, no insurance, invalid license, those are statutory offenses. So while she's trying to elevate this into a constitutional showdown, the court is dealing with standard vehicle code enforcement. That disconnect is widening fast.
You do not have jurisdiction over me. You do not have judicial authority in North America. You are working for a municipality called the state of Michigan. You have no jurisdiction. You are an attorney. You work for a corporation. You are in a municipal capacity. You have no authority. You call yourself government. Your position is a public servant.
Miss
I am the objection.
Miss Seeley,
no, you cannot proceed as an attorney. Objection. I will not be showing up in court. I will appeal this matter. Objection.
There's no question pending to you, ma'am. This court will be muting you at this time because this court... The court has muted Ms. Seeley as her responses are not responsive to the matter that is before the court. This matter is being scheduled for trial. If Ms. Seeley wishes to absent herself from that trial, that is her absolute right. That trial date is January 23rd
I will not be showing up.
That concludes this matter.
And there it is, the common law court question. This is a classic sovereign citizen line of argument. The belief is that only a common law court has authority over a living person, and statutory courts are somehow corporate or illegitimate. The judge answers clearly, this is the 34th District Statutory Court of Michigan handling criminal and civil matters. That's exactly what district courts do. There's nothing unusual about it. But notice how she ignores the answer because it doesn't fit the narrative. Once someone commits to this line of reasoning, every response that contradicts it is dismissed as invalid. And from the court's perspective, that's not a legal dispute, that's noncompliance.